In this video, we are going to analyze an important landmark case of the ECJ regarding fundamental freedoms. In the following session, we are going to study Marx and Spencer case of the ECJ. But you have to remember that in this first part of this seminar, in the previous video, we have studied the interpretation and application of primary law, and in particular, the four fundamental freedoms of the Treaty on the Functioning of the European Union made by the ECJ. We have checked that the ECJ has interpreted not just primary law, but also the different directives established within the European Union. For example, the Merger Directive, Interest and Royalties Directive, and so on. But in this particular case, we are not focused in any particular regulation of the European Union, but just in general in primary law by treaties. This landmark case that is one of the most famous of the ECJ was established or was pronounced in 2006. In this particular case, the request was submitted in proceedings between Marx and Spencer, an UK company, and the United Kingdom Tax Authority concerning the rejection of a claim for tax relief by Marx and Spencer, which requested to deduct from its taxable profits in the UK losses incurred by its subsidiaries established in Belgium, Germany, and France. In UK, in the United Kingdom, as usually in other member states, corporation tax is charged on the profits of companies which are resident in the United Kingdom or which conduct trading activities in the United Kingdom through a branch, agency, or permanent establishment. The difference among those situations is the following. Resident companies incorporated in the United Kingdom are charged to corporation tax in respect of their worldwide income, so under the unlimited tax liability scenario. On the contrary, non-resident companies, so branches or agencies of companies established in other countries, are charged to corporation tax only in respect of the profits attributable to their UK branches or agencies. So, under a limited tax liability scenario, they are taxed just for their source-based income. Within the United Kingdom, group relief allows the resident companies in a group to compensate their profits and losses among themselves. So inside the United Kingdom, group of companies can compensate losses and profits inside them. Marx and Spencer was in this moment and is now a company incorporated in England and Wales. This company, Marx and Spencer, is the parent company of a number of companies established in the UK and also in other states. This one is one of the leading UK retailers of clothing, food, homeware, and financial services. In the UK, Marx and Spencer claim group tax relief in respect of losses incurred by its subsidiaries in Belgium, Germany, and France. The subsidiaries had no permanent establishment nor branches or agencies in the United Kingdom and had never operated there. So in this situation, we have a parent company Mark and Spencer, located in United Kingdom, and we have also different subsidiaries located in different member states of the European Union. Mark and Spencer wanted to create a group of companies in order to compensate losses and profits from one to another company. But the main question was that those subsidiaries did not act inside the United Kingdom. The claim made by Mark and Spencer for relief or create this group of companies for tax purposes were rejected by the tax authority of the United Kingdom on the ground that group relief could only be granted for losses recorded in the United Kingdom. So taking into account that those subsidiaries did not act or operate in United Kingdom, those losses were not created then. So it was these losses were created in Belgium, France, and the other countries in which these subsidiaries act. The main question in this situation is if such provisions, the absence of the possibility of compensate losses of subsidiaries not established in the United Kingdom is or not a restriction on the freedom of establishment and risk by the primary law of the European Union. As we have said, this possibility, the creation of a group of companies for tax purposes, constitutes a tax advantage for the companies involved. By speeding up the relief of the losses of the loss-making companies, by allowing them to be compensated immediately against the profit of other group companies, such relief confers a cash advantage. So if we can compensate losses with profits, the final amount of our corporate tax will be lower. As we all know, for each decision, ECJ always follow the same scheme. First of all, we have to check if there is or not a restriction. So, if cross-border situations are treated in a different manner of national or domestic situation. Under the ECJ opinion, the exclusion of such an advantage in respect of the losses incurred by a subsidiary established in another member state, for example, Belgium, which does not conduct any activity in the parent company's member state, in this case, United Kingdom, is of such a kind as to hinder or prohibit the exercise by that parent company of its freedom of establishment by discouraging it from setting up or from creating subsidiaries in other member states. Once we know, or once the European Court of Justice has decided that there is a restriction or discrimination, the following step is trying to discover if there is or not a cause of justification. According to what established by the ECJ, it must be accepted that by taxing resident companies on their worldwide profits, so those obtained in United Kingdom, but also on those obtained abroad, and non-resident companies only on the profits from their activities in United Kingdom, in the source state, the parent company's member state, United Kingdom is acting in accordance with the principle of territoriality. However, the fact that does not tax the profits of the non-resident subsidiaries of a parent company established on its territory does not justify restricting group relief to losses incurred by resident companies. So, although the principle of territoriality permits the application of different kinds of taxation to resident and non-resident company, worldwide taxation against sort-based taxation, under the ECJ opinion, this does not justify the impossibility of application of internal compensation of losses in the same group of companies. The United Kingdom put forward 3 different cases of justification for the restriction applied. On the one hand, the need to protect a balanced allocation of power. According to the United Kingdom opinion, in tax matter, profits and losses are 2 sides of the same coin and must be treated in the same way. Another cause of justification or another reasoning done by the United Kingdom is that if losses were taken into consideration in the parent company's member state, they might well be taken into account twice. So if Mark and Spencer, as an United Kingdom company, wanted to compensate losses obtaining abroad with the profit get inside the United Kingdom, maybe those losses were also taken into account in the Belgian or French companies in countries in which the subsidiaries are established. And finally, United Kingdom also understood that if the losses were not taken into account in the member state in which the subsidiary is established, there will be a risk of tax avoidance. So mainly the cause of justification argue but the United Kingdom was the balanced allocation of powers and the need of prevention of tax avoidance. The ECJ understood that if we take into account together of all of these causes, we can conclude that this restrictive provision established under the English national system are compatible with the treaty and constitute overriding reasons in the public interest. So, although there is a restriction, the ECJ in this case considered that it was justified in taking into account the need of a balanced allocation of power and also the need of prevention the tax avoidance. But finally, in the last step of its analysis, the court has considered that the restrictive measure at issue, remember the lack of possibility of compensate losses obtained abroad with the profits get inside the United Kingdom, goes beyond what is necessary to attain the essential part of the objective pursuit in the case that the non-resident subsidiary has exhausted the possibilities available in its state of residence. So, summarizing the conclusion of the ECJ, we can see that for this particular situation, a group of companies in which some of them are established in United Kingdom and others are established in other different member states, if we can apply or deduct the losses in the state in which subsidiaries are established, the United Kingdom provisions prohibiting the compensation of losses and profits is correct, but in the case in which we cannot deduct or use the losses in the state in which subsidiaries are established, the parent company country, so United Kingdom in this case, should permit the application or the compensation between losses obtained abroad and the profit that we have in the United Kingdom. Thank you very much for your attention and enjoy the video. Thank you.
Bye, Carmen. Thank you.
Thank you.